here.
Well, this is kind of a good topic for lunch, I suppose. Estate taxes really started out being called death taxes. And you might think that that's really kind of a process that was started by virtue of the United States IRS, but it's really not. It dates all the way back nearly 3,000 years to about 700 BC with the Egyptians, who also taxed their people with a transfer tax. So it's been around for a long time, and as you know, the Egyptians were big on death. So anyway, in the United States then, we have these taxes becoming part of the fiber of our country in about 1797 with a thing called the Stamp Act. And if you remember your 5th or 6th grade history, all the Stamp Act was a way to pay for the Revolutionary War. So we've had this tradition in the U.S. for a long time of having a tax imposed upon a person that's died in order to pay for various things with the country war and all the other kind of things that taxes pay for. And so with that kind of historical idea in mind, then we will accelerate up to 2011. And at this point then, you have some factors that you need to consider when you're talking about estate planning. One would be that the estate tax rates are determined by Congress. And that's been a fluid subject since Bush #1. And during his presidency, the Congress enacted a process by where the estate tax rates would increase up until 2010, and then they would go away entirely. Well, that's also called a sunset law, and the sun set on it on December 31, 2010, and so the new Congress, with President Obama in charge, if you will, decided that we wouldn't let the estate tax go away. And by the way, Oklahoma has done that very thing. A guy that practiced with our firm for a while, Todd Lamb, was instrumental while he was still a senator in getting law passed at the state level that phased out the estate tax for the state of Oklahoma entirely, and it entirely phased out in 2010. So the state of Oklahoma doesn't get any money from people dying anymore for roads or any of that kind of thing. It's completely gone.
Or our wars.
Or wars or anything like that. Roads or wars or bridges or whatever it might be. So in Oklahoma, at least for residents of the state of Oklahoma, the state does not have a tax anymore on transfers at death, or gift tax for that matter. So we're in pretty good shape as far as the state. We're really competitive, and I think that was part of the process, was to be competitive with Texas, which doesn't have that kind of thing either. So we're in good shape there. Now, but back to the federal process, the estate tax for years, from at least the 70s when I know anything about it, up until Bush won, the tax rates for estate taxes had continued to rise. But the exemptions had also continued to rise. I think when I first started doing this, the exemption rate was like 175,000 or so, and by the time the Bush 1 got in office, it was around 1 million, and then it accelerated all the way up in 2009 to 3.5 million before it finally went away entirely. So from that historical perspective, then we have the Obama Congress coming in early 2011, late 2010, passing a new law to prevent the sunset effect. And so what we have now for 2011 and 2012 is an exemption from estate tax for estates that are $5 million or less, and actually for married people, for couples, it goes up to $10 million rather, because each spouse has a $5 million exemption that they can use.
I'm just going to see if anybody looks relieved.
Yeah, which really is a pretty good deal, because a lot of small businesses, which in Edmond and in Oklahoma in general, you'll have a lot of small business people that are looking at these kinds of things, and between two people, $10 million can really be helpful. So you aren't looking so much anymore at I think at the tax issue, although that can still be a problem, because if you go over that $5 million for a single or $10 million for a couple, the tax rate is pretty significant. It goes up to around 35%. It goes up to 35% for anything above that. So it's pretty significant in terms of the cost that you could incur if you get above that exemption level. And there are various ways to deal with that, with gifting and other things like that. But those are also factors then with an estate plan just in general. And I think Christian is going to talk a little bit more about tax aspects of this. But from the legal side, we're going to talk a little bit more just about the planning and the transformation of the estate from a father and mother possibly to children or whatever it might be. So you have control and timing of distribution of assets that's a factor. Avoidance of probate, and everybody that comes into our office is generally concerned about avoidance of probate, because they know that it's costly. They know they have to pay attorney's fees on those things. There's no way to escape that. There's court costs, publication fees, and then just the time that's involved. And if you've had a parent or aunt and uncle or a sibling or anything die, lately you know that process can go on for, at the speed of light, it would be 6 months, and normally that's going to go on for a year or so to get those transfers made and get it all the way through the process. And it can be an expensive proposition. Plus, you're filing things at the courthouse so that everybody in the day and age of the internet, you're filing things at the courthouse that lets anyone that's interested know what you have. And a lot of people don't like that aspect of a probate either, and I can understand that. And then liquidity needs of the heirs. I mean, how much money do they need to keep going, especially in the surviving spouse situation? And then business transition and asset distribution among the heirs. Again, a lot of times you're talking about a small business or a family farm or something of that sort, where you've got an asset that's been in a family for decades and they'd like to keep it that way. With the estate tax exemption fairly high for this next 2 years, a lot of the family farms are going to be okay on that. But then again, you're back to that iffiness of what might happen in 2013, because again, these tax rates are going to sunset December 31 of 2012, and we'll have another new Congress potentially in 2013 with new people involved. What might they do? So you've still got a little bit of iffiness there. Okay, so the estate then can include various types of property, and not an exhaustive list, but some of that would be real estate, stocks and bonds, cash and bank accounts, insurance, retirement accounts, annuities. You could have personal property, you could have collectibles, jewelry, antiques, those kinds of things. So what method should we look at to plan our estate? And there's several things that you can do. One is to do nothing. And I've not had a single person come through our firm lately that did nothing that didn't turn out to be a nightmare. And the most simplest and most common nightmares that you have is a spouse dies and they have a house and it's not in joint tenancy for one reason or the other. And then you've got a couple of kids. Maybe one of the kids have moved off to Maine and they don't care what happens in Oklahoma anymore. And under the intestate law in Oklahoma, the surviving spouse gets 50% of the estate, and the kids, however many there are, split the other 50%. And so you can have a kid that has no connection with anything anymore, maybe even angry with the surviving spouse, with an interest in that spouse's home, and they can cause that to have to be sold. So doing nothing and letting it go by intestate succession is generally a pretty bad idea. I mean, you just run into all kinds of problems. The court determines who the personal representative will be, and the personal representative is the manager of the estate, if you will. So you start with this intestate succession problem with the 50% kind of thing, and you go to the point where the judge gets to decide who the personal representative is, and you can run into all kinds of problems. The next thing you could do is a holographic will, and that's where you write your own will out entirely by hand and tell everyone that's involved what you would like to have happen with this. And again, you can run into execution problems with that, and if you do, and the will is thrown out by the judge, then you're back to the intestate succession laws, and again, we have those kind of problems. So what we encourage people to do at our firm is to at least look at preparing a will. In a will, you can determine what you would like your property, what to be done, where the property would be transferred, who would receive it, in what percentages, those kinds of things in a will. You also can determine who you can suggest to the court. They don't have to follow this, they normally do. You can suggest to the court, if you had children, young children, who the guardian might be, who you would prefer that it be, and you can also name your personal representative, who again is the manager of your estate. And an estate becomes kind of like a small business, and it can be a big business too, depending on the asset base. So you get to do several things with a will that are directives to the court that the judge has to follow, and the lawyers who are involved, and the heirs more particularly have to follow. And with a will, it'll be in writing, it'll be executed by the party, it'll be self-attested, which means that you don't have to prove the signatures and all that when you take it to the courthouse. And it's a pretty good way, if you don't want to have too much money involved in an estate plan, it's a pretty good way to at least have something there that your heirs can rely on and know what you intended while you were alive. So you've got that aspect of it. And again, these self-proving wills are pretty standard anymore. I mean, they've been around for a long time, so all the probate judges that you run into in Oklahoma would be pretty familiar with that kind of thing. You wouldn't have too much problem. Problems with a will, though, can be that, again, you've got this probate aspect to it, you've got the cost, you've got delay, you have attorney's fees involved, and then if you have heirs that have moved away, let's say you don't have small children anymore, but your children are grown and they've moved to Texas and Wyoming and wherever else, and they don't really know what you own, then you're going to put that onus on them to, marshal those assets and file an accounting with the court so that the judge knows what, when you file your final account and request a final decree to have the property transferred to whoever it may be that's entitled to it. You as the personal representative, it may not know what the parent had, and you've got that problem to deal with. So that brings us to the next aspect of this, of an estate plan, which I think that we generally prefer and we generally encourage people to at least look at, depending on their asset base and how complex their ownership may be of various things. We, a lot of times, recommend, or at least we recommend that people look at a trust. And the kind of trust we normally would be talking about would be a revocable trust, which is one that once you sign it, you can still change it any way you want. As long as you're alive, you can get rid of it entirely, revoke it. That's basically why it's called a revocable trust.